PVL3701, Study Unit 2, Number 1, Introduction. In any legal system with a strong Roman-Dutch element, the distinction between real rights and personal rights, or creditors' rights or claims, forms the basis of the division of the patrimonial law into the law of things and the law of obligations. Besides having systematic value, this theoretical distinction has practical significance, since different legal consequences ensue from the different rights. Although the term personal rights is generally employed and accepted in South African legal literature, it has been criticized. Some authors prefer the term creditor's right, but the term claim can also be used to denote the right to performance which a creditor has against his or her debtor, in terms of an obligation. In this study manual, we will use these terms interchangeably. A personal right originates from an obligation, which in turn arises from a contract, a delict, or various other causes, such as unjust enrichment or unauthorized management of another's affairs, called negotiorum gestio. An obligation is an abstract legal tie between two specific legal subjects in terms of which the one party, the creditor, has a right to particular performance against the other, the debtor, and the latter a corresponding duty to render such performance. Then you can study diagram 4, from which we can see two obligations arise. First, obligation A. X and Y, creditors, have a personal right against S, debtor, for payment of the rental amount. On the other hand, S has the right to occupy the leased premises. Obligation B. S, creditor, has a personal right against X and Y, debtors, to use the farm for grazing purposes. The other side of S's rights entails that X and Y has the duty to make the farm available for grazing. Then you can also see diagram 5, personal rights in terms of delict. Okay, the characterization of real rights is furthermore not merely an academic or theoretical exercise. Since the introduction of Section 63, subsection 1 of the Deeds Registries Act 47 of 1937, which provides that personal rights may not be registered over land. This distinction has become fundamental in the law of things. As an exception, Section 63(1) allows for the registration of a personal right where such a right is ancillary or complementary to the registrable real right. See the discussion on ex parte geldenis below. The distinction between real rights and personal rights has its origin in Roman procedural law, with its division of remedies into real actions, actionis in rem, and personal actions, actionis in personam. Roman law stressed the procedure, and therefore the action rather than the right released by means of the action was considered to be of cardinal importance. A real action focused directly on the thing concerned and could be instituted against anyone who was in control of the thing. A personal action, on the other hand, was always directed against a particular person or persons, who were bound to the plaintiff in terms of an obligation to perform. With the passing of the centuries, the emphasis shifted from procedural law to substantive law, and the distinction between real actions and personal actions became a distinction between real rights and personal rights. We indicated above that the law of things deals inter alia with real rights. Roman law specifically categorized actions into real rights and personal actions. Roman Dutch law mentioned specific categories of real rights. These were exclusive, and it was not possible to create new real rights. This is a so-called closed system, numerous clauses of real rights. In time, with the creation and development of other rights, such as mineral rights, it became necessary to recognize new types of real rights. For various reasons, including systematic reasons, a clear distinction had to be drawn between real rights and personal rights. creditors' rights, or claims. Several theories were subsequently developed in an effort to identify the exact nature of a real right. None of these theories succeeded in providing a conclusive test to separate real and personal rights into watertight compartments. At most, these tests can be used as guidelines in an attempt to distinguish between the two. Number 2. Theoretical distinction. Two important theories that have gained acceptance over many years are, first, the personalist theory, and secondly, the classical theory. 2.1 Personalist theory. 2.1.1 Content. This theory is called the personalist theory because emphasis is placed on the person against whom the right may be enforced. In terms of this theory, a real right operates absolutely, in the sense that it is enforceable against the world at large. Recognition of and compliance with such a right, for example, ownership, may be enforced against anyone. Whatever my relationship with someone might be, that person will have to recognize my ownership of a certain thing, and I can, in principle, claim my thing from anyone who is in control of it. For example, an owner can claim his car from a person who bought it from a thief. A personal right or creditor's right or claim, on the other hand, has relative operation. It can be enforced only against the particular person who is obliged to perform. For example, S in example 1 above can claim use of the farm from X and Y, the other contracting parties, the debtors only. In a delict, damages can be claimed only from the person who causes the damage, apart from certain exceptions. Therefore, S can claim the damage caused to his car from Z only, not from his father. See example 2. 2.1.2 Criticism. The fundamental criticism leveled against this theory is that it overemphasizes the absolute operation of real rights, and in reality, such rights do not always and necessarily operate absolutely. There are cases, for example, where the owner of a thing is prevented by the operation of estoppel from enforcing his or her right of ownership against another person. Estoppel is a defense which operates against the re vindicatio of an owner if he or she has culpably created the impression that a third person was the owner or had authorization to alienate the thing. Furthermore, personal rights do not always have only relative operation. In exceptional circumstances, they operate absolutely and have to be respected by outsiders, such as in the case of a service contract. It has been held that an outsider may not intentionally interfere in the relationship between an employer and an employee. The above criticism is valid to a certain extent, but it overemphasizes the exceptions in each of the categories of rights. Generally, the theory is valuable in determining the nature of rights in this context. Another objection to the absoluteness of real rights in personalist theory is that other rights, such as personality rights, for example, rights to physical integrity or reputation, and immaterial property rights, for example, patent rights and copyright, also operate absolutely. This argument also has little substance, since this theory is used to distinguish between real and personal rights for a particular reason. It is valuable in demarcating the boundary between the law of things and the law of obligations, but in particular in determining which rights may be registered against land in terms of section 63(1), subsection 1 of the Deeds Registries Act 47 of 1937. 2.2 Classical theory. 2.2.1 Content. This theory is known as the classical theory because it corresponds to the original Roman law distinction. It distinguishes between real and personal rights with reference to the nature of the object to which each right pertains. Real rights, according to this theory, concern the relationship between a person and a thing. A real right confers direct control and the right of disposal over a thing. Personal rights, on the other hand, concern the relationship between persons. A personal right entitles the creditor to claim performance from a particular person only. The object of the right is therefore performance. 2.2.2 Criticism. Although this distinction is open to criticism, we think that in most instances this criterion will help to determine whether one is dealing with a real right. However, it is sometimes difficult to determine exactly what is meant by a direct relationship with a thing. Certain personal rights ultimately also have a thing as their object, but they are not real rights. An example would be personal rights to acquire a thing. Juria in personam ad rem acquirendum. Such rights are in question when, for example, X buys a car from Y. In terms of the contract, X has a right to the car, but this is merely a personal right. Before delivery, X has a personal right to claim delivery of the car. X acquires the real right ownership only after delivery of the car to him or her. Number 3. Distinguishing characteristics. Although the theories referred to above are open to criticism, and neither of them can serve as an all-inclusive, absolute basis for distinguishing between real and personal rights, they may even be said to overlap. Each theory contains important elements which are indicative of the inherent characteristics of real and personal rights. The development of law cannot be put into a straitjacket. The law very often evolves according to considerations of efficacy to meet the needs of the community it serves. Some jurists, such as Meyer, the father of the modern Dutch civil code, propagated the view that one should identify the typical features of each type of right. This is a useful method, but some of the so-called typical features are really descriptions of the consequences of the particular right after it has been classified as a particular type. Typical or prototype or real rights and personal rights have the following distinguishing characteristics, respectively. First, the object. The object of a real right is a corporal thing, leaving aside the exception of a pledgee of claims, whereas the object of a personal right is performance, to give something, to do something, or not to do something. Secondly, content. The holder of a real right, has a direct claim to and a right of disposal over a thing, whereas the holder of a personal right is entitled to claim performance from a specific person. Third, remedies. The holder of a real right can enforce his or her real right by means of a real action, such as the re vindicatio of the owner, which can be instituted against anyone who is unlawfully in control of the thing. While the holder of a personal right enforces his or her right by means of a personal action such as the condictio furtiva, the action of a person with lawful interest in the stolen thing, or an owner against the thief to claim back the stolen object. And fourthly, origin. Real rights have their origin in legal facts other than obligations, for example, delivery of movable things and registration of land, accession and prescription, while personal rights come into existence through obligations, for example, in terms of a contract. Fifth, absoluteness. Real rights are absolute in principle. The holder of the right can vindicate his or her thing, subject to certain exceptions from whomever is in control of the thing. While personal rights are relative in principle, the holder can enforce his or her right only against the person who is obliged to perform in terms of an obligation. 6. Preference. In the case of insolvency, a real right enjoys preference over other rights. Moreover, the maxim first in time is stronger in law, prior in tempore est putior in jure is applied in case of two or more competing real rights. Apart from a few exceptions, this principle does not apply to personal rights. Seventh, publicity. The creation, transfer, or extinction of real rights requires some form of publicity. This takes the form of delivery in the case of the transfer ownership of movable things, and the registration in the case of immovable property. The reason for this lies in the nature of real rights. Since these rights have to be respected by the world at large, it is imperative that there should be some form of publicity informing outsiders of the existence, transfer, or extinction of the real right. These distinctive characteristics serve only as guidelines in identifying real rights and personal rights, and are not intended to serve as an exclusive means of classification. In Study Unit 1, we define a real right as a lawful relationship between a subject and a thing which confers direct control over the thing on the legal subject, as well as the relationship between the legal subject and all other legal subjects who must respect this relationship. After you have read the above explanation, this definition of a real right should make more sense to you. Number 4. Subtraction from dominium or ownership test. In a system where there is a closed category, numerous clauses of real rights, characterization of real rights is unnecessary because the system determines which rights are real rights. In an open system, such as the South African system, where the existing range of real rights can be extended, it becomes essential to determine the basis on which new rights will be categorized. The existing categories of real rights or real rights recognized by Roman Dutch law are ownership, servitudes, real security rights, quitrent, and leasehold. On occasion, notably when mineral rights were developed in South Africa, the law has been confronted with new types of rights which have had to be classified as either real or personal. Apart from the theories referred to above, the courts have also formulated a test to determine whether one is dealing with a real or a personal right in a particular set of facts. In Ex parte Geldenis 1926, the court formulated the subtraction from the dominium or ownership test as follows. One has to look not so much to the right, but the correlative obligation. If that obligation is a burden upon the land, a subtraction from the dominium or ownership, the corresponding right is real and registrable. If it is not such an obligation, but merely an obligation binding on some person or other, the corresponding right is a personal right, or right in personam, and it cannot, as a rule, be registered. The facts of this case are simplified in the example above. In applying the above test, the court came to the conclusion that the provisions that the farm must be divided when S reaches the age of majority, and that the drawing of lots will determine who gets which portion of the farm, place a burden on the land itself, in that the time and manner of division restrict the ordinary rights of co-owners to divide the common property when and in a manner on which they agree. These provisions were regarded as conditions aimed at creating real rights and could therefore be registered. The provision that the heir who gets the portion with the homestead on it must pay a sum of money to the other heir was regarded as creating a personal right, since it was only an obligation on a specific person to pay a sum of money, and a claim for payment of a sum of money is, as a rule, not regarded as a real right. Bear in mind that this condition placed an obligation on that person in his or her personal capacity, and not the owner of the land. However, the court held that, since the latter was so closely related to the real right, it could be registered as an exception. Although this test is not without value, one could criticize it on the following grounds. First, it is not possible to identify the most important real right, ownership, dominium, by means of the subtraction from the dominium or ownership test. How can one define ownership by having recourse to this test, if the test requires that the right concerned should limit ownership? The test can therefore be applied only if ownership has already been determined and identified by means of criteria. In other words, the test can be used to only to identify limited real rights to other persons' property, jura in re aliena. And secondly, personal rights can also impose restrictions on ownership. The criticism in the first can be countered with the argument that the test was not developed to determine the real rights of ownership, which is clear and has been resolved. The test is an aid to determine which rights qualify as limited real rights to land which can be registered. The criticism in the second is also largely without substance. It is true that personal rights limit the exercise of an owner's ownership. Such a limitation is, however, not comparable to restrictions imposed by limited real rights. Note that a personal right which limits the exercise of an owner's ownership still has its object performance by the specific owner. This performance cannot be exacted from the owner's successors in title. In example 1 above, where S has a contractual right or personal right to use the farm for grazing purposes, this right can be enforced against X and Y only. If they sell the farm to Z, a third party, Z is not bound by the contract, and therefore S cannot enforce his personal right against Z. A limited real right, on the other hand, has its object on the thing itself. Has as its object the thing itself. The right and the accompanying duty remain connected with the thing concerned, regardless of who the owner of the thing is. In example 3 above, M has a personal servitude, a servitude being a limited real right, of habitation over a homestead on X and Y's farm. If they sell the farm to Z, a third party, Z is bound to respect M's limited real right because M has a right to the thing itself. He therefore cannot eject M from the homestead or in any other way interfere with her exercise of the right. The South African courts realized that the subtraction from the dominium or ownership test cannot be applied without qualification. Accordingly, the parties are required to have envisioned that the accompanying obligation would be binding not only on the present owner but also on his successors in title as well. In other words, the parties must have intended to create a legal right. It is clear that the courts do not apply the subtraction from the dominium or ownership test without considering the additional requirements as well. You should bear in mind that it is not always easy to apply the subtraction from the dominium or ownership test to a specific set of facts, and that the distinction between real and personal rights is one of the most problematic areas of the law of things. The Supreme Court of Appeals has confirmed this test in Cape Explosive Works Limited versus Denel Proprietary Limited 2001. In principle, only real rights may be registered in the Deeds Registry. Section 63 of the Deeds Registries Act 47 of 1937 expressly provides that, excluding provisions in mortgage bonds, leases, including amendments, cessions, or cancellations thereof, and deeds of grant as contemplated in Section 3 subsection 1c of the Act, no condition to a deed which purports to create a personal right on immovable property, and no condition which does not restrict the exercise of ownership on immovable property, shall be capable of registration. This section, however, authorizes the registrar to accept such a condition for registration if, in his or her opinion, it is complementary or ancillary to another registrable condition or right in the deed. Registration of such a condition, however, does not convert the right it may contain to a real right. See ex parte geldenis from 1926, which prompted the present wording of Section 63. Number 5. Categories of real rights. Having established what real rights are, we must draw a further distinction between ownership, which is a real right to one's own thing, as in re propria, and limited real rights, which are real rights to someone else's thing, jure in re aliena. Ownership is, in principle, the most comprehensive real right to a person's own thing, whereas limited real rights to someone else's thing are, in principle, limited in scope. For example, in principle, the owner of a piece of land can use his own land as he or she wishes, whereas the entitlement of a usufructuary, which is the holder of the personal servitude of a usufruct, limited real right, exercised over the land of another, are clearly defined and limited from the outset.